tuned in to The Andrew Lawton Show.
The big news of the week has not been the flip-flop of Ken McDonald, but it's been the federal courts' trump card, if you will, on the federal government, declaring that the use of the Emergencies Act was unlawful. It did not comply with the Emergencies Act, and the measures employed did not comply with the Canadian Constitution. We've talked a lot about what this means in terms of the legal arguments that are being put forward. We spoke a bit yesterday on the longer-term implications of this and what it'll mean if it goes to the Federal Court of Appeal and most likely beyond that to the Supreme Court. But I wanted to delve into this in a bit more detail because there have been a lot of questions. And one big one is how this has been such a divergence from a lot of the other case law on constitutional freedoms in the last few years, which have been, as I've said on the show, very deferential to the government and not particularly mindful of protecting people's freedoms. James Manson is the Director of Legal Services with the Justice Center for Constitutional Freedoms and joins me now. James, it's good to talk to you, and I should say to my audience, by way of disclosure, I sit on the board of the Justice Center for Constitutional Freedoms, but that has no bearing on this interview, and this is not to be taken, James, as a performance review by your board.
Thanks very much, Andrew.
You showed up on time, so you're getting a passing grade so far. But welcome. Let's start there. I mean, we've seen a lot of dismal rulings on constitutional freedoms in the last several years, on COVID-era cases, on free speech cases. Why did this one, in your view, go the other way? Like, where was the judge going with this that we haven't seen many of his colleagues go?
That's an excellent question, Andrew. And, you know, I have been struggling with the answer to that question for a couple of years, probably like you, probably like a lot of the viewers and listeners. Why is it that these courts have been so unwilling to, even consider the Charter of Rights or consider these very important issues dealing with all the COVID stuff? Why were they so unwilling to do that? And yet, a couple of days ago, Justice Mosley comes right through and gives us that win that we were looking for so desperately. Why was that the case? And I think part of it may be legal. There may be a legal answer to part of that. There also may be a psychological answer to part of that. Now, I'm not a psychologist, of course, but I think that back in those days, 2, 3, 4 years ago, we all remember the fear, right, that was going on in our society. There was a lot of it going on. And I mean, I think maybe some of us felt it to a greater or lesser degree, but I think a lot of people in society were very, very afraid. And I think that fear extended throughout society, which would include government, the judiciary, a lot of people in positions of authority. And I think a lot of this may have come from the reticence, the fear to say, I can't take a position on this. I can't hear this. I'm too afraid of getting COVID and getting sick and potentially dying, or, all of the horrible things that we were talking about back a few years ago. I think a lot of that may have been partly what was responsible. And so the reason I say that, Andrew, is because now we're 3 years later. We're 4 years later. We're not quite so worried anymore about COVID. Now COVID is a bit of a punchline. I don't mean to be that glib about it, but people say, oh, I got COVID over the weekend and it sucked and I had to stay home and no big deal. That's where we are now with COVID, right? So I think partly there's a psychological explanation. But the other explanation, Andrew, is more in my bailiwick, which is legal. And so I think maybe the COVID stuff was much more scientifically driven. It was much more about, whether there is a scientific explanation for vaccines or whether or not staying at home is the right thing to do medically or whatever. And there's all these scientific expert reports flying around for all that stuff. And the courts were really reticent to get involved in all of that because, of course, expert opinions, expert evidence in the courts, it's always very, very tricky. And in this particular case, we weren't really talking so much about any of the stuff that was really COVID, really hardcore COVID stuff. It was a totally different question, which was about the Emergencies Act, which is a very, very, complicated issue, but it's very legal. It's very constitutional. It's much more, it's something that a judge or a court would have much easier time grappling with in the abstract than COVID, science, medicine, all that stuff. And I mean, don't get me wrong, Andrew. I totally think that the courts should have gone there anyway with all the science.
Mhm.
They totally should have. But that ship has already sailed, of course.
Yeah, I mean, to find a judge who is an expert in science and medicine is very, very difficult. It's incredibly rare. So judges have to be deferential to the experts. And when the government puts out, all of these people in lab coats, it's very easy to say, well, okay, that must be science. And your point about the legal aspects, I think, is incredibly important. Now, I'm not a lawyer. I kind of play one on TV sometimes because I've studied these cases and covered them. And I have people like yourself whose expertise I get to claim credit for in later shows when I repeat it back to my audience. But the Emergencies Act is a very well-written piece of legislation, I think, in terms of spelling out the test. And I actually found it very easy to go kind of point by point through all of the premises and caveats that it gives and try to line that up with the government's argument. And to be honest, there was not a lot of subjectivity in the test for a national emergency, in the test for a threat to the security of Canada. The only time you got into a pretty ambiguous territory was when it talks about cabinet has to have a reasonable belief, because they're carving in a bit of subjectivity there. But that was where I thought Justice Mosley's decision was much stronger than Commissioner Rouleau's decision in the Public Order Emergency Commission, because he was really accepting the government's very muddied and muddled interpretation of that legal test, whereas Justice Mosley was much stricter and more literal with it, which is, I think, how it was intended.
I agree. I totally agree. I can't improve upon your comments, Andrew. I mean, I think that. We're talking about two different animals, obviously, the Public Order Commission and then this. And I think the listeners and viewers know all about what those two different animals are designed to achieve. One may be totally different than the other. One is subject to appeal, and one is subject to much more rigorous cross-examinations and evidentiary requirements, and the other one is not, etc., all that stuff. But I think really what every reasonable observer needs to admit at the end of the day is that this decision from the federal court is much more authoritative, shall we say, with respect to the actual text of the legislation, the actual intent of the Parliament in bringing it into effect. I mean, remembering this all came out, Andrew, from the War Measures Act back in 1970, and the whole debacle of the FLQ crisis. Basically, Parliament got together and said, we have to change this. It has to be much harder to invoke these very, very stringent, very, very serious powers. And this is what they came up with, right? And so to say that the government suggested, or maybe Justice Rouleau acquiesced in, to suggest that it should be easy, or that it should somehow fall to the executive, to cabinet, to just be able to do this whenever it basically wants to, is crazy, in my view. It is totally anathema to what Parliament did in enacting this brand new piece of legislation 50 years ago, right?
Yeah, and I wanted to ask a little bit about the mechanics of the next step. We know the federal government is going to be appealing this, which means it will likely go to the Federal Court of Appeal. I've heard several lawyers say that the Federal Court of Appeal is almost certainly going to take this up, given the circumstances. But I'm curious, and I don't know if you can actually drill this down into a statistical analysis, but how commonly are trial court decisions from the federal court overturned by the Federal Court of Appeal, or is it really a toss-up?
Yeah, I don't have that statistic. You could probably, I'm not sure if you could find it if you looked. I can tell you, though, that in this particular case, first of all, just so that everybody's clear, it's not a question of whether they will take it up. They have to take it up. Mm-hmm. If the Federal Court of Appeal gets a notice of appeal from the government, they have to do the appeal, because the government and anybody on our side also would have the right to an appeal in this case. The second appeal, which in this case would be to the Supreme Court of Canada, that one would need to be done by permission. You would have to get what they call leave to appeal. So anyway, we're in the first step. This is an appeal as of right. which means that you can appeal it. There will be an appeal. Now, the question becomes, what happens on the appeal? You know, there's different tests and different factors and different things that happen on an appeal based on the type of proceeding we're talking about, okay? So this isn't a trial with a jury, for example. This was what we call a judicial review. I don't need to bore everybody with exactly what that means. It's a bit different than just a regular case. But basically, when you go on appeal from this decision, from a judicial review, the standard of review, which is what we use to say, what does the Court of Appeal do? What is their function? What are they looking for? Sometimes the appeal court has got a very narrow function. They're only looking for some place where the judge made a mistake, screwed up, did something really, really wrong. In other cases, like this one, basically it's kind of a rehearing. It's kind of a do-over. Not entirely a do-over, but kind of a do-over, which is to say that what the appeal court has to do is take a look at the lower court judge's reasons and determine if they basically applied the right standards of review to the declaration, and whether or not they applied it all properly. Now, that's all very formal language to say it's kind of a do-over. So we're going to have to see how much of a do-over we're talking about here. Are we going to literally have 11,000 pages of the record put before the Court of Appeal? Are we going to have a multi-day hearing in the Court of Appeal? Is it going to take months to get there while everybody prepares their briefs again a second time? I don't know as I sit here. I hope not, because I don't want to have a totally second kick at the can on the part of the government. My thinking, my hope anyway, is that this is going to be a fairly tailored process. But nonetheless, it's possible that we get into everything all over again, that we get into the mootness again. It's possible that we get into the national emergency finding again. It's possible that we get into the national security threat finding. It's possible that we get into the Charter of Rights again, because of course the Section 2 and Section 8 violations of with those regulations, those horrible regulations, freezing people's bank accounts.
Yes.
It's possible that we have to revisit all of that. And given the way the government is going these days, that they seem to be completely unable to recognize and respect the rule of law. I'm sorry to be so spicy when I say that, but it appears like I honestly can't believe, Andrew, that a government would consider appealing a decision like this.
Well, yeah, I mean, I can't believe they would have done the first thing, which was freezing the bank accounts from the get-go. So
that's a fair point.
I mean, their only real recourse is to just keep digging in and hope that eventually they're going to get some seal of approval from a court, I guess.
Well, and as you said in your last segment, I mean, we're not going to get help from Mr. Singh, so
yeah,
it's basically 2025 or bust, right?
Yeah, very, very well said. James Manson is the Director of Legal Services with the Justice Center for Constitutional Freedom. Thank you so much, James.
Thanks, Andrew. Cheers.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.